he knows that. He's finding that out.
He is doing a good job, though. He really does really well with the Architecture Review Board.
Right. I let him run the meetings. I just kind of like, sit in the background and, but he runs with it. So.
Ladies and gentlemen, it is 7:01. I'm starting the webinar.
Thank you for the
Christy.
reminder, Christy.
Hi, Christy.
Thanks, Christy.
Hello. We're all set. You can start the meeting.
Thank you. So the February 23rd, 2022 meeting of Chagrin Falls Planning and Zoning Commission will be called to order. We just had one item on our agenda tonight, which is revisiting some changes to section 1111 of the zoning code. I think everybody was here last time and we talked about it. And Nancy and Rob worked with Dale to sort of incorporate our more changes from Dale, and incorporated, I think, comments and suggestions from our discussion last month. So hopefully you all got it in email last week and had a chance to look at it. I think a big problem that we had before was the organization of, especially in 11-1101. It was a big block paragraph that was pretty complicated and talking about a number of different things. And so now we have it broken out into subsections, which I think will help make that more understandable and easier to navigate. I like the way, Dale, you did it, if you're the one that did that, or Nancy or whoever.
It was a collaboration of the three of us.
Yeah,
Nancy, I give Nancy most of the credit.
Yeah, well, thank you. I think it's helpful. And what's up?
I can screen share the next.
Okay, yeah, that way maybe we can just go through it and try to move on. I know Dale's got a big night planned for his wedding anniversary.
That's
So
right. Congratulations.
happy
Thank
anniversary.
you. It's only 48.
48, exactly what you want to be doing on your 48th anniversary, right?
Well, at least we're in Arizona.
There you go. That's good.
But it did snow here today.
Wow.
Oh,
Oh, that weird front that's going through the south.
Yeah, it happened exactly 3 years ago today also. We got 7 inches then. Today it just snowed for a little bit.
But it looks pretty on the red rocks, and it's very nice.
That's actually Chagrin Falls.
No, I mean, I recognize Chagrin Falls, but I meant it probably does look nice where you are, maybe.
Yeah. Yeah.
So I found a couple of little things, but we can maybe just go through it, starting at the beginning. Anybody chime in or raise a hand if you have anything you want to say about this first 11-1101. I just saw in section B, I think the if not at the red end of the red is maybe a duplication, because it says if the standards set out in subsection 11-1101A are not applicable, then the Board of Zoning Appeals shall follow, I think. So I think we need to delete that. Oh, wait, it's gone. In mine, it doesn't look crossed out. Sorry.
Yeah, I had that too.
That's weird.
Yeah, same thing. Mine wasn't crossed out either.
Okay.
It's
So I think
not
that's
crossed.
fine otherwise. And I didn't understand the number
What you're seeing on
one.
the screen, is the way we revised it.
Okay, yeah, what we got, that the if not at the end of B, the first part, was not crossed out. So that's all. It's fine the way it is. I didn't understand the one there. Is there two? elsewhere?
No, just one. Part of that reasoning to break it up that way was you had said to us you wanted to see it broken up more, so we created a subsection. C, formatting wise, should look like B, so the margins need to be fixed.
Okay, so we'd have A, B, and C. So A is when we're modifying the planning and zoning code. B is reviewing other decisions of P and Z or decisions of ABR. And then C so C would apply to both A and B cases?
Yes.
Okay.
Well, no, actually, when you look at it, the standard that we're talking about for C is not for variances. All we're saying though, it's like the answer to your question is yes and no. I hate to say that, but C really doesn't apply to A when there's a variance, because those standards are for other than that. But because we say if the decision was based on incorrect interpretations or unlawful, unreasonable, or abuse of discretion, those are matters that are like when we're reviewing Architectural Review Board judgment calls of that nature. So in C, by default, it would never really apply to a variance.
So should C maybe say if a decision of the Planning and Zoning Commission or the Architectural Board of Review was based on blah, 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 an incorrect interpretation? Because it's just when you say if the decision, sort of kind of makes it seem like it would be following from the decisions you were talking about above.
Standards on that approval.
I think it refers back to number one, doesn't it? The decision.
Maybe the thing to do here is to make that a 2 rather than a C. Make that part of B.
B above, not B under 1.
Yeah, and then we've got 2 A's and B's. Which-
No, this would be B2 rather
Right.
than C,
Mhm.
which makes more sense because if O1A doesn't apply, we're talking about modifications by the Planning Commission, which they do on site plan review.
Yeah, I think that would help if it only applies to B. Then
And remember,
maybe it could be B1 and B2.
yeah, and when we're talking about variances, that's really covered under another section, which is not, it's not all there. This isn't the entire chapter.
Mhm.
So let's make this a 2.
Yeah, because under 1A, you say, they'll determine if the decision was based on a correct interpretation of the ordinances. And then what you have as C is if the decision wasn't based on a correct interpretation. So it seems like, yeah, maybe that would help to have it be C. I mean, to have it be 2, not
Yeah,
C.
I think you're right.
Does anybody else have a?
Yeah, I don't know about that. Because A is saying if the decision was correct, then that's one thing. If the decision was not correct, not unreasonable, so the decision was either correct or not correct. And C is what to do if you're saying that the decision was incorrect.
No, but Nancy, now that I'm looking at it, A is saying that there's when there's a modification, it's like a variance. So you're dealing with the normal review standards for a variance. and they're saying follow 07, 08, and 09. And so B is saying that if A doesn't apply, then you follow the abuse of discretion or unlawfulness standards.
You know what, Dale? I think we're just looking at the wrong A's and B's. So Nancy's talking about A, the first A, which refers you to 11, 07, 08, and 09. But I think you're talking about the A that's within, under the B1.
No, I'm talking about the same thing Nancy is.
Oh,
Yeah, but that's not, that whole section isn't about variances. It's all about reviewing a decision of BZA or ABR or the administration. Those are
Well,
all,
no, these are all BZA reviews.
yeah, but they're not, they're reviews of, they're not variance reviews. They're reviews of ABR, P and Z, or the administration, or a building permit denial or something like that. They're all administrative reviews. So
They are, but the reviews are being done by the Board of Zoning Appeals.
right. And this is telling them how to review, what to look at. Right?
Right? Yes.
So now you moved it down too much. Well, I mean, I'm looking at this, yeah. So one, they're going to first determine if the decision was based on a correct interpretation. Then if the decision, so let's say it was, then you end there. If the decision was not unreasonable,
We only have the two scenarios in B1, but I think that it's still maybe somewhat awkward the way we've got it, because
I don't know, it sounded right at the time, but
because we're really talking about incorrect interpretations or unlawful, unreasonable, or abuse of discretion. Those are all references to what's in B1. That's why I'm thinking Patty is right, and it should be B2.
but could it apply to the first A, the A that's not shown on the screen right now?
No.
If we've acted to modify a part of the zoning code, that could be determined to be based on an incorrect interpretation or to be unlawful or something, right?
Well, not really, because you're doing a modification. You're not being asked to interpret the code. I mean, anything that any board does has got interpretation in it. But what they're talking about is if somebody comes to you and says, I want you to interpret the code to cause section so-and-so to apply to my project. And you say, no, it doesn't apply. That's not a modification issue. That's just an interpretation issue. If somebody comes in and says, I want you to modify chapter 11, whatever, so that I can get more lots for my subdivision, and you interpret it to say, no, we can't do that. We don't have the power under the code to do that. That's still that's still an interpretation, but you're denying a request to modify.
But like it says abuse of discretion. So what if somebody came to us and said, we should modify the planning and zoning code so that we can have, whatever, this size lot or something. And, four of us vote for that because we're friends with the person proposing that. That would be considered an abuse of discretion. So then in that case, C would apply.
so, yeah, but looking at it again, A and B are probably sort of not the same, but the same concept, that where the decision is correct. Basically, it's where the decision is correct and not unreasonable or abuse of discretion. And then when you get to C, then if it was incorrect. So A and B are both for correct, for a correct decision. It was not
And it
unreasonable.
has an and there. So you have to have under one, the board will determine if it was based on a correct interpretation and it was not unreasonable or an abuse of discretion. So then the alternative would be,
So
C.
there is an and there, actually.
Yeah.
You took out the then if. So yeah, so it's the same. I mean, it's correct.
So maybe we don't-
interpretation. Correct interpretation and not unreasonable.
So
Yeah, there's a
maybe,
little bit of words
maybe
there, but
that A and B should just be A.
well,
And
I
in
think,
case A would be,
I think we separated it out because it was too much of a mouthful of a sentence to have it in
Well-
one sentence.
And it was
But in-
several
in
different
C-
points of criteria to consider.
in C, you have it all together based on you have incorrect interpretation, unlawful, unreasonable, and abuse of discretion for things.
At the end of the day, I don't think it's going to matter whether we call it C or 2.
Okay,
It's just, what do they call that? Synaptics or something? It's,
Yeah,
your call here, but I could be comfortable presenting it to the council either way.
so you want to make it turn it into 2.
Well, if you do, then I also have to fix B by saying the following subsections. I got to make that plural. But
maybe it's just the way it's lined up on the way it printed out for me because it's got A, B, and then 1, and then C is, I don't know, I just couldn't tell where C belongs. If it's part of the A, B, and C that should be the main subsections, or if this C is part of the paragraph 1.
I think it follows A, B, and C under one.
Is
It's
that
just
correct?
It's just that it looks like you made another paragraph out of it. Maybe you should. Maybe it belongs up. Maybe one has just one longer paragraph.
Yeah, is C part of that paragraph 1 that has A and B within it?
Yeah,
no,
this whole thing was that whole big long paragraph, and it just really separated
Right.
it out.
Yeah, no, I agree with separating it out. I'm just
That's
confused.
all. Very little of the actual wording was changed. I mean, some of the otherwise and that stuff, that's grammar. So it was the same thing we had, but separated out so that it was easier to read. Because I think we all thought that it was just one big solid bunch of words. And, it was hard to see where you were supposed to pause and change your thought.
how about if we leave it as C and we just fix the margin? There's no harm in having it be in a separate subsection.
So the C that you've got showing there will move to the left. It's not part of paragraph 1.
Right, it'll look just like A looks.
Oh, I see. Okay, A and B. Okay.
Right. And I tried to fix the margin and I can't. I'll have my secretary do it.
Mhm.
But that's one of my word processing weaknesses is margins.
Okay, I think that will help me a little bit. Does anybody else have anything about 11-1101?
It looks good. I can scroll down if you like.
So.
Okay, I'm okay with that. Anybody else? Should we move on? Okay, I don't see anybody
Yeah,
raising their hand or
yeah, I'm
Nancy, are
not-
you okay moving on?
Yeah, well, we can move on, but I'm not crazy about making C like because C is part of, maybe it should be 1, 2, 3, and 4 instead, because those two concepts are part of what you do. I think it's telling BZA what standard of review it's supposed to use when it's looking at various things. And that's what, the first part is what they look at if it's a correct decision, not unreasonable. And C is if it's incorrect or unlawful. So
Okay, so Nancy, what if we,
maybe it could be renumbered, but it needs to all be under B, and I don't know what was above B, because it's all the standard of review.
okay, so what if we have B say, if the standards set out in subsection 111101A are not applicable, then the Board of Zoning Appeals shall cut the rest of that sentence. I don't see what that really says. Shall, 1, first determine if the decision was based on a correct interpretation of ordinances and regulations of the municipality, and the decision was not unreasonable or an abuse of discretion, where discretion is permitted. And then 2, if it was based on an incorrect interpretation or was unlawful, blah, blah, blah.
I don't think you could take out all that rest of that paragraph.
Well, no, you would still have it in there. You'd still have it in there. It's just you'd have B, if the standards set out in subsection 111101A are not applicable. And under B, you would have 2 things. The first thing would be this paragraph numbered 1. You'd get rid of A and B in there. You could reword that to make it more concise and less wordy. And then number 2 would be what we have as C.
I don't know that, well,
Because you're saying there's two cases under B. You're saying under B, this is what you need to do. You need to either 1, show that it was a correct interpretation of the ordinances,
okay.
or 2, that it wasn't a correct
Well, you could
interpretation.
Make C into 2. Is that what you're saying?
Yeah,
Okay, well, that's okay.
Okay.
that's what
I'm
we started
changing
out
now-
with.
I'm changing it for the 12th time, but that's okay.
And Dale, do we need A and B in there? I know we were trying to break it up with subsections, but A and B are saying the same thing, right? And it just,
No.
it
Not
repeats.
really. I think we
No,
need
they're-
all that.
They're not saying the same thing.
Yeah, A says it's the correct interpretation, and B says it wasn't unreasonable or abuse of discretion.
Okay, I was just wondering if you could make it shorter by not repeating ordinances and regulations of the municipality, but that's fine. Yeah,
Okay,
if you're
so
saying that it
then-
only relates to B, then we should make it number 2, I think.
Right.
And then the margin would stay where it is, Dale. You won't have to fiddle with a margin.
Good. I like that.
Is that all good with everybody?
Yes,
Okay, Dale, you got that?
Got it.
Okay, Nancy, that's okay with you?
Yes, thank you.
Okay. And then, so the next part is 111103. I don't think there's anything in here that is significantly different than what we had looked at last time. Did anybody have any comments or anything about 111103? Seems like it's mostly just wording kind of changes. And then in C, It's been broken out with the lowercase i's or Roman numerals, I guess you'd say, to make it a little less of a block of text. My only question would be under Roman numeral 3 is any property owner who can prove they would be especially damaged. Could it be later in here somewhere, there's something about any interested party? Does this have to be a property owner? Could it be?
Well, we don't want anybody in the village filing an appeal. And what the statute says, if somebody wants to file for an injunction where there's somebody violating the code, they have to prove they've been especially damaged, which is why we use that term here. So the idea here is that either somebody who's asked for the permit, somebody who got a stop work order, somebody who is a contiguous owner, or somebody who is within that zone of who gets notices of a meeting, or somebody who can prove that they're especially damaged, which is going to be hard for somebody to do who's not in that zone of those who get notice. But we don't want somebody on the northeast end of town filing an appeal to something that happened on the southwest end of town.
Or like the president of the Historical Society couldn't file an appeal on behalf of like the Historical Society saying that, you know, I don't know.
He would have to find somebody nearby who's been
Okay,
damaged in some way.
okay. And that's the policy we currently have, right? That hasn't changed.
That hasn't changed, and that's the law in Ohio
Yeah.
to file in court.
Okay. Did anybody else have anything about 11-11-03?
I do not know.
Okay, all right, we'll move on then. Then we've got 11-11-06. And we did change this to the chief, or under A, changed it to a chief administrative officer to be consistent with what actually takes place rather than the secretary of the Board of Zoning Appeals. And it previously said immediately upon the decision. So now we have as soon as possible, because we had a discussion last time about, well, what does immediately mean and how reasonable is immediately? As soon as possible seems sort of vague, I guess, but
So
Is
is
it?
immediately.
right,
There's no, all this really means is that the time for that 15 days to start running doesn't happen until the notice is given by the CAO. And he's going to do it as soon as he can. Rob, to my recollection, in the past 3 years, has already done it either the same night or the following morning from when the decision's made. And almost every time it's the same night.
That's correct.
I wouldn't want to change it because we could have an emergency occur right after the meeting and Rob can't do it.
Right.
And he's got to attend to some emergency. So
okay,
this is not a life or death notice.
right, because the clock doesn't start until it happens, so
Right.
it doesn't have to be a firm amount of time or a set amount of time.
Dale, one spelling thing under subsection B, it says when written notification by the chief administrator officer, it should be chief.
Yeah.
Administrative,
Yeah,
Yep. Yep. Got it.
minor.
Yeah, well,
Thanks.
no. Yeah, thank you. Good catch.
Also, further down in the what's showing on the screen there, where it says the Board of Zoning Appeals to Council. Further down, second line up from the bottom,
Mhm.
including it's there.
Mm-hmm.
oh, right,
Oh.
right,
Yeah,
Yeah.
well, I think it should be it's, because I think it's singular.
Right, but then we need to delete there.
Yeah.
Oh, double, yeah,
Right. Good catch, Matt.
it's decision, yeah, I changed it, but then didn't take out the other thing. Or you didn't.
It's amazing how three of us could look at this thing 100 times and you miss.
Yeah, well, don't take out,
Obviously.
don't take out both words.
No, I'm taking out there.
Okay. Because it looks like,
I think originally, Nancy, it was there. You changed it to its. I
Yeah.
changed it back to there, and then we agreed on it, and
yeah, okay.
didn't remember to take it out.
Are you gonna fix administrator up there?
Yeah, I already did.
Oh, I'm not seeing it here.
Well,
Well,
that's Rob's copy. I can't change his copy.
Oh,
Are you doing this in the Google Doc that's online?
What's that?
Are you doing this in the Google Doc that's online or?
No, we're not.
Oh, okay.
Rob, is that a PDF or a Word?
yeah, it's a PDF.
Okay. Yeah.
I do have the Word version, but I'm just sharing this because it's the format I had set up to share.
Good luck, Matt, trying to get the village to go to Google Docs.
yeah,
It was a struggle to get them to go to Word.
Not completely.
yeah.
Some offices,
I haven't
not mine.
gained a fondness for Google Docs.
Anything else on 11-1106? Anyone see that? Okay. 11-1107 is a section that we did not have last meeting. Rob, I believe, introduced the concept and said it would be coming. And Dale, if you want to say anything more about it, that's great. But it basically is saying that it sets the possibility of, presents the possibility of making a conditional decision. Is that
Right.
correct? That they can set
Yeah.
conditions for
Yeah.
approval or,
Yeah, there's a dispute as to whether or not you can do it without specifically providing for it in the code that came out of a recent case. So we decided, let's end the dispute and just make it clear that they have that power. So that's the only real change we made to 11-1107. And we give council the same power as well.
what about planning and zoning?
That's not a variance, that's a modification. I'd have to look at the code, but I think you already have that. Let me pull
Yeah,
that
I mean,
up.
we've done it before. We've, said,
Yeah.
condition upon doing whatever. Whether it's written out in the code for us to be able to do that, I'm not sure.
It's in the subdivision regulator, wait a minute. It's in, like, in our, overlay districts. Let me pull that up. Like in the mixed use, we provide for it. Let me see what we said. Modifications to area yard and buffer requirements. The Planning and Zoning Commission may modify requirements regarding areas, yards, setbacks, and distances between uses if compliance with these requirements is either clearly infeasible or contrary to compliance with the design regulations and standards of this section. Doesn't say anything about conditions there.
I
You
mean,
would
I don't
have
think
to-
it would be long in this section we're talking about now, but
No,
the fact
we
that you
got-
felt like it had to be added in for variances, is it something that needs to be added in some other section for P and Z to be able to do the modifications to the code that we, or to, code regulations that we do sometimes?
Yeah,
I think I do recall language where it says modify with conditions somewhere. I'm not sure.
But this is variances. This is.
Right, I know.
Yeah, so that would be a different section,
Yep.
but
That's for a future change, if
Well,
we
but-
need one, but if you felt like it was necessary to add it in,
I think we should add it, but let's do it in a separate ordinance. I'll draft something up and come back to you for planning commission to consider next meeting.
Yeah.
And same thing for ABR. I think they clearly frequently make decisions saying, we'll approve this as long as you
No,
change
but-
this one window or,
They're allowed to.
No, but they don't have the power to modify the code. They
okay,
don't have, they only have, they can make judgment calls, but they can't determine that they'll grant, variances or modifications, so it wouldn't apply to them.
okay.
But 113009 C needs to have the ability to impose conditions. And Rob, it might be somewhere else, I just doubt it, because that would normally be where it would have gone.
Okay, but yeah, that's, Nancy, as you pointed out, it's not relevant to this section, but does anybody have anything for 111107, the way it's written? Is it okay? I didn't have any problem with it. Nope.
That's okay.
Okay, we will move on to 111110. And
D had changes.
we had this pretty much the way it is last time, I think, except for the new red. We had the underlined part last time.
Dale, I'm just checking, I think there's checking the word that I've highlighted.
The other change that we had was in the first sentence. We changed it to say quorum for review of the Board of Zoning Appeals decision and took out transaction of business. I'm not sure why that doesn't show in your draft. I think what you have up there is not showing all the changes from what Planning Commission last saw till now, Rob.
This
Because
is,
it's not.
I don't know why, this is the copy that was last sent.
Yeah, I noticed it in a couple of the other sections too. But I'll just run through when we get to something that's material. Can you scroll down?
So
Can you scroll
Rob
down
was,
to H? Yeah, that looks the same as mine. I'm sorry, Patty, what was that?
Rob had a word highlighted in D, which I guess maybe is a law school word, maybe what is movement?
Nobody knows what that means.
Someone who moves,
The person who made the motion. I see.
motion, yeah.
Yeah,
Yeah, that's a good word. That's a good word. I'm just looking
yeah,
at
it is a good word.
it. Yeah.
I'm gonna use that in Scrabble and now I look really smart.
It's a person who applies to or petitions a court or judge for a ruling in his or her favor.
Okay,
I thought it made,
I learned a new word.
sense.
yeah, it makes, you could sort of guess, but
Yeah,
I make sure that it wasn't supposed to be something else.
Yeah, Dale,
I'll
are
make
you
sure it
saying,
was a word.
are you saying that first sentence is supposed to be instead of decision for doing business, for conducting business?
No. We took out transaction of business. We
Okay,
deleted that, yeah. And what we're seeing here in the movement issue is it doesn't only have to be the movement who can provide facts to support a motion.
or other.
It
counsel.
can be also by others who
I see.
support the motion.
Okay, I'm good with that. And H,
Agreement with her findings, yeah.
so here, Dale, in H is where there's the any interested party. Any
Yep.
interested party who appeared at a council meeting where the matter was heard.
Are we done?
I was at H, but. So here you're talking about who can appeal council's decision in reviewing the decision of BZA. Is that what you're saying?
Mm.
Right,
So
before it
here-
said- Earlier, it had said that anybody who claims to be harmed could appeal the decision to court. And that's not what the case law in Ohio has been saying for the last 50 years. They have always said that it's got to be somebody who appeared either in person or by counsel, and they opposed, because we don't want to have the village and the applicant get sandbagged by somebody who doesn't show up for any hearings and then all of a sudden files an appeal to court. They should come to the hearings and present their position. And that's the way it is in every community I work in, without exception.
Okay, so just to be clear, this, you don't have to be a property owner.
You still got to show you have been harmed. So you could be a renter or an owner, or you could be somebody who, I suppose, could somehow prove harm in some other way, but
Oh,
typically.
and because of this so you have to appear at the meetings, you have to present your position and prove that you've been harmed.
Right, so in your example,
Okay,
if John from the Historical Society showed up, he doesn't live in the village, and he says, "Oh, I don't like what you're doing on this variance," he's got to show somehow how he was harmed.
okay. I didn't pick up on the and. So I was thinking we're saying that any interested party who appeared at a council meeting where it was discussed could then,
Yeah, before it was anybody who claims they were harmed can appeal.
okay.
So we're trying to narrow the class of those who can appeal. We got enough litigation and potential litigation going on as it is.
Yeah, we had that discussion last week about, or the last meeting about harmed and all that. So this reads much better. Yeah.
So I have a question though about the Zoom meetings. Do we know who's attending meetings on Zoom?
We do, because we have the recordings and we record them to give their name and usually we get their address, but not always.
What if they don't speak at the meeting?
Then they have to prove that they were there. But they have to present their position on the matter. So they can't just sit there and say nothing.
I don't know. It seems kind of like a high bar. I know you don't want a bunch of litigation, but I mean, what if you're quarantined for COVID? What if you're an elderly person? What if you have written 20 letters about this, but the letters aren't admissible and you can't get to a meeting? Or what if you miss the cutoff to be put on the agenda to speak? There's a lot of ways that, if you followed this stringently, somebody who, has a legitimate case that they were being harmed might not reach the standard to being able to appeal the decision.
I disagree with you on policy reasons, but what I could say as a compromise is we could take out presented their position on the pending matter. Sometimes you get somebody who's afraid to speak. Or you could have a situation where it's a long meeting. 12 people have said the same thing that you were going to say. And so somebody will say, "Oh, I don't need to get up and say it." So I suppose we could take out, even though the Supreme Court has determined that for standing, you have to have opposed. There's a famous case out of Lake County on that, but we can determine who has standing in this ordinance. So if you want to say they have to either appear in person or by, the representative, and then take out the presented their position, I could be okay with that.
And I'd like to do that. I'd like to add in that you could send a representative. And I'd like to take out the part about presented their position. Because like you say, sometimes they actually cut off discussion in a meeting that's gone on for, 3 hours or whatever. And I think, isn't there a deadline? You have to get on the list to speak. Is that correct, Rob?
No, not for a public hearing.
Not for a public hearing.
For a public hearing, you can just raise your, be acknowledged.
Okay.
Right. Yeah, because
Well-
council has to hold a public hearing.
Mhm. That would be my my request would be to change it to any interested party who appeared at the council, who appeared in person or by designated representative at the council meeting where the matter was heard and was harmed by the action of council may appeal.
Okay. Yeah.
Should we take a vote on that, or because it is sort of a different, it's a, material change, or,
Yeah, except that Patty, you still have to be an interested party to begin with.
right?
And you have to prove you were harmed. That's always been in there.
Yeah, so,
So the only difference now, so what we have now is that you have to prove you're harmed. What we would be adding would be that you also have to have appeared at the council meetings,
In person or by
in person or by
representative.
representative.
Right. Yep.
Is that okay with everybody? Does anybody?
Can you
Disagree.
repeat that? Can you repeat that?
Why don't I read it? The applicant or any interested party who appeared or was represented at the council meeting, parens, where the matter was heard and was harmed by the action of council, may appeal council's decision pursuant to Ohio RC Chapter 2506.
So we'd be taking out that middle part where you would also require that they presented their position at the meeting.
Correct.
Because sometimes it's, for whatever reason, maybe somebody didn't actually speak at the public meeting.
well, yeah.
Well, how are you
Yeah.
going to prove that you're harmed?
Yeah, that's what we had the discussion about last time, is like the part, Dale, where it says and was harmed. According to who?
According to the court makes that determination, because once they've appealed, that issue is out of our hands. But at least we're giving the court a standard that we want to have in place for those who can appeal. Every court is always going to say you have to have been harmed. The principles of standing in Ohio indicate, regardless of the case, it could be a zoning case, or it could be a car accident, or somebody alleging a trademark violation. You have to show somehow you've been damaged or harmed. So that standard has been in the code probably ever since it was adopted. It's in every code where there's some language about appeals. If we were silent on the subject, there would still be the requirement to show harm.
That's to win the case or actually hear the case. But what we have here is that in order to appeal to the court, it says you have to be harmed. You have to be
Right, but-
harmed to appeal.
But that's what the court looks at. The court will say, were they harmed? We don't look at it and say, oh, you can't appeal, it's thrown out. We don't have that power. That's for the judge.
Okay. So even
All
if,
we're doing-
as long as you believe you were harmed, you can appeal. And the
No.
court might say, no, you weren't harmed. Your case is out of here.
That's right. It's not a subjective determination. It's an objective determination made by the court.
By the court, though, not by,
It's a question of law decided by a judge, not a jury, and not by the law director or the applicant who appeals. It's
Okay.
made solely by a judge.
okay.
It's what we call it's a jurisdictional issue. If you can't show that you've been harmed, the court has no jurisdiction to hear the appeal.
So just to be clear on this, presented their position. So if there was a hearing and somebody showed up and a letter was read and 30 people had signed it, would that be considered having your position presented?
Well, we don't allow letters in public hearings to become evidence, because that's hearsay and it's created problems infinitum. So you have to be there and you got to speak and you got to be subject to cross-examination.
So you can't I couldn't stand up at a hearing and say, I have a petition here signed by 30 of my neighbors. Here's their official signatures. I'm here presenting it. And that would not present the position of my neighbor officially.
That we usually, I always ask the board to say that you should not accept it. And we get letters all the time in advance of the meetings. And I always tell, Rob or Harry or whomever, that should not be given to council or to the Board of Zoning Appeals, because only you are seeing it, and it's unfair to the other parties, so that nobody knew what the position was. You have no right to cross-examine. And to me, it's a due process constitutional issue. And so we don't take those things. Now, a petition that says, we're the neighbors on South Franklin, and we all believe that the variance should be denied. And that gets presented to council. Now you've got people taking a position, but you have no way to cross-examine it. So we don't want that to go into evidence. Now, are there times where somebody walks up to the board and hands it to them and says, here's a petition signed by my neighbors? And it happens once in a while, and I'll say to the board, you should not accept it or consider it as evidence.
But what if the letter is read at the public meeting?
It's still hearsay, and it's still, somebody couldn't cross-examine the letter writer. We don't follow all the rules of evidence at the hearings, but on the right to cross-examine, one of the reasons why we follow that is that if you allow in evidence where there's no right to cross-examine, then if somebody gets turned down for a variance, let's say, and they go to court, they can have a whole new trial in court by filing a motion under 250604 of the revised code saying, I was denied the right of cross-examination or confrontation, and therefore I'm entitled to put on all new witnesses again. And then we got to put on our case, and you get into the battle of experts. We prefer to have the record be the record before the board, and that's it. Hopefully that clarifies that for you.
It does. Thanks.
Yeah.
Roger, anybody else? Do you want us to read that one, the proposed revision to H again?
Yeah, yes.
Can you do that one more time, Dale?
Yeah, hang on one second. I got to exit my full screen and go back. Okay, the applicant or any interested party who appeared or was represented at the council meetings where the matter was heard and was harmed by the action of council may appeal council's decision pursuant to Ohio RC Chapter 2506.
That's fine.
Yeah. Dale, you feel that's okay?
Yeah, I'm okay with that.
Okay.
And you're saying this is the standard in Ohio law that you have to be present at the meeting?
Well, in Ohio, the courts have said you have to also stand up and oppose.
Right.
Yeah, we're not even requiring that. So
Okay.
we're making this a lesser standard than exists
Okay.
by common law.
Okay.
So I'm sorry. Are you saying that even though if we take that phrase out of there, that this person could go to court and the judge would say, sorry, you didn't state your position at the hearing, goodbye, you're out, and dismiss the case?
There hasn't been a case on that in decades, on where the community gave a right to appeal that was, let's say, a less strict standard than the courts have declared otherwise. I don't know what the court would do. They probably would say that they have jurisdiction because we've granted that right. We've given that person a property interest to appeal. I'm not 100% sure that's what would happen. And there's some judges who couldn't care less, and they're going to, try and throw out cases as often as they can and say, no, they had to have stood up and opposed because Supreme Court said in the CC Sahara case that, you have to stand up and oppose. But, I can't help that. I can't change that. All I can do is try to accommodate what I think the majority of you want, which is to try and give more people the opportunity to be able to appeal. I'm not sure council would agree with that, but I'm not. It's not an unreasonable position for you to take, And I think it's a reasonable compromise that they at least have to show up at the hearing or have their attorney or their mother-in-law or somebody there.
Yeah.
I'm
So
good with
if
it. I'm good with the way you read it, Dale.
Okay,
Do you want to take a vote on it, Nancy, or?
I don't know. I mean,
Should we, Dale, since it's a material change?
yeah, I
sure,
mean, I
go
guess,
ahead.
Okay, I
Yeah,
mean, I don't want to, have my position steer things, so I would make a motion to, or I'd move to modify 1111.10 H to read, hopefully I get this right, Dale. The applicant or any interested party who appeared or was represented at the council meeting or meetings where the matter was heard and was harmed by the action of council may appeal council's decision pursuant to Ohio RC Chapter 2506.
Correct.
Is there a second to that motion?
Second.
Okay,
Can we do a real roll call, Harry or Rob? Sorry.
Who had the second?
Roger.
Okay. All right, Baker,
Aye.
Khan,
Aye.
Davis,
I,
Hicks,
Aye.
Rogoff.
I'm gonna vote no.
You preferred my original language?
I did, because my concern is that somebody would, without that language, somebody would go to court and the judge says, forget it, goodbye. And that person then is angry and feels that they were not properly advised by the village. Because we've given them permission that the judge is either ignoring or disregarding or believes is incorrect.
I think they'll still be advised by the village to show up at the meeting and speak and make their position heard.
No, Nancy's point is they won't know that, and we're not gonna be going at every meeting saying, oh, by the way, if you ever want to appeal this to court, you gotta stand up and oppose it now. That just isn't gonna ever happen.
So Patty, was your suggested change in the motion, everything shown except for the highlighted section on the screen?
Yes, but also after appeared, you would have who appeared or was represented.
Okay,
Right.
let me write all this down.
Yeah, Rob, I've made all the changes already on my Word version here.
Okay, I just have to make notes for what we have.
Yeah.
on.
Do we actually have there been cases where people that have not showed up at any meetings or spoken at any meetings have appealed a decision to the court?
I'm not saying I showed up, Patty. That's not,
I'm just curious if this is something that happens a lot, or if it's usually, if it's going to go that far, it's somebody who's been pretty invested and has showed up and that they don't like the decision, they've had a history of being involved.
It has happened, but not in my tenure as law director in Chagrin Falls. I've had it happen in other cases. Usually it happens in townships where they don't think about putting in this kind of language.
And it can always go to court and then get thrown out. And, you know, if the court decides that there's no harm or that they don't have standing because they didn't present their case, or there wasn't a good reason for why they didn't present their case, then they can throw it out and it's no skin off the village's teeth anyways, right?
Right, but Nancy's point is that it's fairer to give them notice that they have to stand up and oppose if the court is going to impose that requirement. I don't know the answer to that question. I don't think they will, but I'm not positive.
Because right now we don't have anything in our code that even says you would need to go to a meeting,
Correct.
or that the letter that you wrote and had 50 neighbors sign is not going to be considered. So, you know, there's a lot of lapses, I think, if you're saying we should tell people exactly what they need to do.
Well, the way this read before is the part that's not in red. The applicant has to be an interested party who was harmed by the action.
Mhm.
So you still have to be an interested party, and that has a legal meaning to it.
Right, but your average person might not know the legal meaning of an interested party.
Right. I guess this version that we're seeing here doesn't say, what did you add there? That was appeared or was represented.
Yes.
So
I didn't even say by a lawyer to make it easier.
you,
I mean, they
you
could have a
should, because
family.
represented, I mean, what does that mean? It, you know, like I can go, well, say, my neighbor could go and say that she's representing her other neighbor.
Well, yes, we're saying that, but at least we then know that somebody's there opposing it. We know what their arguments are.
So would that person have to say, I'm representing Susan?
Yes. I mean, they got to prove that they were there representing him. If you say nothing, you know,
Yeah.
good luck convincing a court of that. I could say, or represented by counsel.
I think that's also a pretty high standard to say, you know, that somebody needs to hire a lawyer to go to a council meeting. Before
Yeah.
they even know what the council decision's going to be.
No, I agree. That's why I didn't put it in.
Dale, do you feel comfortable with it as we changed it, or
I'm
you
okay
said you
with
did
it.
before? What's that?
Yeah, I'm okay with it.
Okay. We took a vote on it. Then there was further discussion. Do we need to redo the vote?
No,
What's that?
unless I mean, if somebody wants to move to, you know, vacate the motion, let them speak, but it doesn't sound like you have a majority to do that.
Okay, speak now, or I guess hold your peace.
Right.
Okay, so that's the end of what we've got in front of us. There's some changes. Can we vote to move this to council with those changes, or do we need to have it come back and see it again?
I just emailed it to you all. You'll have it in another minute. So you'll be able to see all the changes. I copied everybody in the planning commission and Rob. Hopefully, let's see if I have a 2-minute delay on my emails. Yeah, it already went to all of you. If you look in
Can you
your-
put that on the screen?
It hasn't arrived in my email
I
yet.
mean, yeah, when it does.
Yep, I'm monitoring.
Now I gotta clean it up, of course, but that has all the changes. We have to get rid of the yellow highlighting. You don't have it yet, Ron? Huh. Do
I
any
have
of you
yellow,
have it?
I have yellow highlighting.
No, no, I was asking Rob if you got the
It
email.
just
Oh.
came through. It just came through. Hold on.
Okay,
Hold on. All right, I got, hold on. Okay, I've got it up on the screen now.
Oh. It's all red.
not the whole,
Now we got to
Not
read
the
the whole
whole-
thing all over again.
no. Just 11.11.01 is mostly all right, because we changed everything in there, moved everything around.
Okay, so can you scroll down a little bit, Rob? So we've got A, B, wait, A, B. Okay, there's A and B, and then you've got 1 and 2. Okay,
And the other change I made is in B, in the second line, subsection became plural.
pardon?
Right,
The
it's
review
there.
standards set out in the following subsections.
Okay,
Yeah. Okay,
and then 11.11.06, I think we had a change in B, just the typos of chief administrative
yep. fix that.
officer and got rid of there. And I don't think there was anything else except for that H in 11.11.10.
Correct. I also
Um.
deleted the ordinance references, which when we submitted to council, we take those out.
Okay.
Yeah.
Is there anything else to point out, Dale?
No,
Well, I'll make a motion to recommend this proposed amendment to council, conditional upon the changes shown here, made on February 23rd, 2022 in Dale's version.
if you want to have a name for it, it's proposed amendment to 11.11.03, 11.11.06, 11.11.10, and 11.11.01 DHMHL NHR DHMHL 2-8-22.DHMHL.3. That's the document name.
Got it. I'm not going to repeat that.
Don't.
And in the motion, I'm just gonna say the proposed amendment as discussed at the meeting tonight.
That's fine.
Second,
Motion by Baker, second by Rogoff. Khan,
Aye.
Davis,
Aye.
Hicks.
Aye.
Rogoff,
aye.
Baker.
Aye.
Okay.
Okay, we will move this to council. And Dale, you can prepare the ordinance for that?
Yeah, I'm trying to decide whether we want it on Monday night's agenda or wait till the next meeting. I'll see if I can get it, in time, to be on Monday, I'll do that.
Okay,
Yeah, because that's still a Zoom meeting though, Monday.
yes.
Right.
So
Yeah,
maybe,
and then we
maybe
we just
wait
have to
till,
set. We have to set the public hearing. I was thinking, put it on first read for Monday and then just set the public hearing and have no other discussion. But if you want to wait till the following meeting, we can.
That's fine, whatever you want to do.
yeah. I haven't seen an agenda for Monday, have I?
No, not yet.
Yeah.
There's a couple of ordinances I just am doing on contracts and there's not a whole lot.
Well, and Dale, we're only bringing that that alley contract if we get that one other piece put together, which I'm
Right.
working on.
Right. So it could be a short meeting. It's probably a good meeting to get it on. The sooner we can get these changes, done, the better we're going to be.
Yeah, if there's not a lot on the agenda, then it sounds like that.
Well, we're also doing the first reading of the budget. And we have that meeting, the committee meeting beforehand. But we're not in a hurry. I mean, it can go to the next meeting. Whatever you
I'll
like.
do this. I'll do my best to get it done in time and then you guys can decide whether you want to put it on the agenda.
Rob, we're not going through that budget, are we?
No.
Reading, okay,
Yeah,
right.
no, it's
So,
not. We're gonna probably set the dates for the presentation hearings at the council meeting on Monday.
Is there anything else for tonight? Anybody wants to bring up? Are we staying Zoom, Rob, or what's?
But it's my understanding we'll all be back in person March 1st.
Do we have a choice about it or no?
At this point, we do not.
Okay, well, thank you, everybody, and we'll see everybody next month.
Thank you all.
Adjourn the meeting. Happy anniversary, Dale.
Thank you very much.
Anniversary.
You made my
Thank you
life
all.
easier.
Anniversary, Dale.
We'll make our dinner reservation. Thanks.
Bye-bye.
Anyway, I was gonna say one thing, that new restaurant, Pony Boys, very good.
Yes.